Thanks everyone for joining us this afternoon. We are quite excited to join you today for the next in a series of presentations that we've had regarding SHRMS 2. My name is Jim Harvey. I'm a partner with Olson & Bird in the Atlanta office, and we are joined by Wim Nauwerts, who heads up our EU data privacy and security practice in Brussels, Peter Swire, who is a professor at Georgia Tech and also senior counsel to our firm, and our special guest speaker, Hilary Wandahl of Dun & Bradstreet. We'll come back for more detailed introductions later on. Just a few administrative matters at the beginning. We are offering CLE credit. There will be a code at the end. If you're in one of those states that requires you to write down a code, it will be provided towards the end of the presentation. And I would also say, note that if you are logged in via audio only, you can't get CLE credits. You have to be on the platform in order to get CLE credits. I hope that doesn't inconvenience you. For CLE credit, also there is a contact on your confirmation form that will be sent out. And so just follow that contact information, and that will kind of activate the CLE process. We're also offering IAPP credit for this. And we will distribute the slides and some other reading materials on relevant topics at the end of the webinar to all attendees. So the slides will be distributed. There is no press participation in the presentation. So if you are a member of the press, please either exit or take off your press hat. There'll be no attribution directly or indirectly to the remarks of the presenters today. If you have follow-up questions for them, we'll be glad to take those questions offline and do that in the normal fashion. But we want to have a good, candid conversation today, and that's easiest done without press remarks. And finally, if you have questions, you can submit them via the Q&A function, which should be showing up in the platform. And we will take those questions to the extent that we can during the presentation, and then to the extent that we need to hold them for the end or follow up with you after the presentation, we'll do that. But there is a Q&A. So with that, I'm going to ask our speakers, initially Hilary and then Wim and Peter, to introduce themselves. We are so pleased to have Hilary today. She's been kind of at the edge of data protection thinking and operationalizing for several decades in her career, and she's recently made a big career move. So Hilary, can you tell us more about your practice and your experience?
Sure, Jim, and thank you so much for the opportunity to join you, Wim, and Peter today. It's really an honor to be part of this session and exciting to talk about one of the most challenging areas that we all are grappling with right now in the area of data protection, I would say law and compliance more broadly, and just even how businesses operate on a global scale. So yes, I am currently in a brand new role. Thrilled to be part of Dun & Bradstreet, one of the oldest companies in America. We just celebrated our 180th anniversary on Tuesday. And for those who don't know Dun & Bradstreet, we are a leading provider of business decisioning data and analytics. And we operate globally around the world, both directly through our subsidiaries and our worldwide network partners. It's really exciting for me to be part of an organization that is data-driven. Data has been at the heart of my entire career, starting as a scientist, but really moving into practice law in about 2 decades ago, where I started right after, as Peter knows so well, the safe harbor first coming into effect, and that really drove the way in which I thought about privacy and data protection and responsibilities back when I was at the global pharmaceutical company Merck in managing privacy on a global scale. It influenced my thinking about our obligations with respect to data, and has really been a big part of how I have approached privacy and data protection over my entire last 2 decades, including in my last role at TrustArc, where one of my big goals was to try to help people solve for this complexity. But here we are with even more complexity to deal with. So I look forward to talking about it with you guys today.
Thanks, Hillary. Wim, a few remarks?
Thanks, Jim. So my name is Wim Nauwelaerts. I'm a Belgian qualified attorney, partner in the Brussels office of Elston & Bird. I've been active in the privacy and data protection field for more than 20 years now, most of the time with US-based law firms. And since 2 years, I'm with Elston & Bird.
So, and Peter Swire, who likely needs no introduction to most of the audience, but Peter, if you can tell us a little bit about your history, which has many consistencies and parallels with this topic, and
Right.
what you're doing today.
I'm just observing. I know that we've heard. I know that Jim's been working on EU-US data flows since the directive came into effect. Wim has, and Hillary has, and I wrote a book on EU-US data flows back in 1998. So these topics are near and dear, and we've watched these things develop over time. As Jim said earlier, I'm a professor at Georgia Tech. I teach privacy and cybersecurity there. I am a senior counsel with Alston & Bird, and I'll be saying a little bit more about the history in my remarks in a minute.
Okay, thanks very much, Peter. So just a few to set the stage. Nearly exactly 1 year ago today, I think today's the 22nd, so last July 16th, the Schrems 2 judgment came out. I woke up, I think with Peter at about 4:30 in the morning to read that, and it's been a long and intense year since then. Then the writing started. So you're going to hear about this theme. Peter and Ken Propp, who's a fellow at the Cross-Border Data Forum, and I think Peter's going to talk about the Cross-Border Data Forum some, wrote about a proposal to meet the individual redress challenge in August. So just about a month after the Schrems 2 judgment. Then the EDPB stepped in, and even prior to the EDPB stepping in, the US government, the Department of Commerce, actually published a white paper to assist with the data transfer process. The EDPB came out with guidance on November 10th that, for me personally, sent shudders up my spine with the severity and the rigor of some of the positions that they took. There were literally hundreds of comments filed in connection with that guidance or that draft guidance, some of which were reflected in the later draft and the final recommendations, and some of which were not. At the same time, the DPAs in Europe, particularly in Germany, got busy. They took Schrems 2 to heart. The Bavarian DPA called for a German company to cease using MailChimp. So that was noteworthy in my mind, because while MailChimp is a US company and a tech provider, they certainly are not Amazon, Facebook, Google, Microsoft, et cetera. So this was, to me, a DPA sending a message, while not a very strong message, but sending the clear message that they would stop data transfer if they didn't think that it was compliant with the law as set down by the court in Schrems 2. At the same time, there was a draft of the standard contractual clauses that came out, and that was finalized on June 4th. And we will talk about that briefly today. We had another webinar on it in May. We're glad to send you the slides from that webinar. That was on the pre-draft version of the SCCs, but that certainly is a part of this overall picture. It kind of can't be ignored, if you will. Dan Felds wrote a blog post. Dan is a senior associate in our Atlanta office, a blog post actually on Wim's advisory on the 10 key takeaways from the new standard contractual clauses. So there's that theme of a lot of writing about this stuff and thinking about this stuff. And then finally, the EDPB on the 21st of June, so about a month ago, came out with the final recommendations on the supplementary measures. This was the final version of the draft that they had put out in November that sent shudders up my spine. And I think it still continues to send shudders up my spine. It got a little better in certain regards, a little worse in others. But the overall theme today is we have to stop thinking about and writing about and talking about the new standard contractual clauses and the supplementary measures and transfer impact assessments. And now we have to start doing them. So I'm going to let Peter give some context. He is uniquely situated to talk about what I'll call the political and diplomatic efforts regarding all of this. Among other things, of course, Schrems 2 took out the privacy shield, and Peter's totally plugged into all that. So I look forward to your remarks, Peter.
Great, thanks, Jim. Hi, everybody. So just to try to provide the context, as Jim said, and as you all know, we're right about at the 1-year anniversary of the Schrems 2 decision. And one way to look at this is the lack of legal certainty that accompanies transfers of personal data out of the EU. And clearly we have these new standard contractual clauses, the new EDPB guidance, and that's going to shape how to proceed currently, the actions that people will take. And that's what most of the webinar is today. What I've been spending more time on is more on the policy side, which is how to help create legal certainty with a new version of the Privacy Shield. And today's comments draw my participation in previous rounds. So during Safe Harbor, I was the White House privacy person and was the White House official on Safe Harbor. During Privacy Shield, I was in meetings in Brussels in the week or two before the agreements were reached between the US and the EU. So this is round 3, and it doesn't get any easier, in part because the rules that come from the courts have gotten stricter, and we have to figure out how to manage with those. Next slide, please. Very quickly, and for many of you are familiar with at least some of these, so the US side has a bunch of things to complain about, critiques that have been made of the situation we're in. I'll briefly mention these critiques, and then I'll say that they really don't matter much because we have to figure out how to deal with the world as it is. So as many of you know, the US actually has extensive safeguards against surveillance abuse, including the USA Freedom Act that was enacted after the Snowden revelations. And I continue to believe in my heart that there's a good case for adequacy. However, the European courts have not taken that view of the US surveillance system. Next is the US safeguards are clearly more in place than other important markets such as China and India. And despite this, the enforcement has been against US companies. That's where Schrems has focused his fire on the biggest digital platforms. But it brings in sort of rule of law issues about the US that are stricter in some ways than exist for other countries that really lack our safeguards against government surveillance. A third complaint is the people making the decisions here, which has been the CJEU and the European Data Protection Board. They don't have any national security authority. That's not, the Court of Justice of the European Union is excluded from national security. The Strasbourg Court of Human Rights is the one that has been working on these issues for decades, but it's the court without experience on national security that's writing the rules right here. And they're making big decisions about what other countries can do for their national security. The European Data Protection Board says it's not their job to worry about national security, but one of the impacts of their strict approaches can be on the national security authorities of other countries. Another thing in the law is that the EU applies a stricter standard to US national security than it does to its own member states. There's a law review by Professor Christina Irion that explains why that is doctrinally, but it does seem strange that we haven't joined the European Union, but we're stuck with their stricter rules about what to do on all this. Another thing is if you've seen the data retention cases in Europe, the member states in important respects have not followed EU legal requirements for government data retention and other limits on surveillance, yet the US is being held to a standard, again, in practice that's stricter. And then for many of you who are living in this world, there are the practical effects. Ordinary business does have cross-border flows. There's potential big disruption here. There's potential data localization here. And that's bad for a lot of different reasons, including perhaps the protectionist approach. So thanks, Jim. those are the critiques, and here's why it doesn't matter. The critiques have not been accepted by the authoritative rule of law decision maker in Europe, which is the Court of Justice of the European Union. And so the holdings in Schrems 2, the two things that have to get fixed. The first one is individual redress, which I'll talk more about in a minute. The second is the European law requirement that surveillance has to be necessary and proportionate, not unnecessary or disproportionate. And Bruno Gencarelli is a name familiar to many of you, who's at the DG Justice for the Commission. And in a conference, I think the week before last, here are some quotes from him. "This is a top priority for us to reach an agreement with the US. There is no shortcut or quick fix. For those who want a quick fix, don't wait for it." And he says, "We won't deliver the legal certainty if we don't meet the Schrems 2 requirements." So the design constraints here are what meets the Schrems 2 requirements and how can that be built in a way that works. Next slide, please. So the issue I've spent the most time on, including for most of the summer, is how can we build a new system for individual redress that would meet the European standards? And here are some of the things European law requires: that the individual, or a DPA or someone for the individual, can file a complaint that the NSA is doing too much surveillance, or that the Russian or Chinese government is doing too much surveillance of them. And even though these countries are not in Europe, European law says for data to leave Europe, there has to be this redress complaint system in place. The redress has to be done with an independent fact-finding process, an independent adjudication. And the word independent in European law is quite strict, can't be removed by a political figure, et cetera. Then when there's an adjudication, the adjudication must have the kind of authority to compel compliance. Hey, NSA, you must stop doing this thing. And there must be oversight that those orders are followed. An order is made to the NSA has to do it, and there has to be a system in place to make sure it's being done. Now, these are European requirements. We have the US Constitution as well. And the US courts, as you know, only allow standing if there's injury in fact. And the mere fact of surveillance, or the possibility of surveillance, is probably not an injury in fact. So it's not clear how you get to US courts. So at the Cross-Border Data Forum, for which Alston's counsel and for which I'm research director, we've been really focusing hard on redress. I've met with the commission team, I've met with the US government and civil society people in recent weeks, and we're really trying to see what can be done here. Next, Jim. Next slide. The big picture, and I think this is my last slide, is as you know, President Biden visited Brussels in June. That's an important trip. He spent time on the EU-US alliance to strengthen it. But the communique that came out only had a vague and short statement on Privacy Shield. There's other things from the Brussels summit that are more concrete, agreements reached, but we're not close enough to have had that kind of presidential level statement, although the Secretary of Commerce with her counterpart in the commission did release a statement talking about its importance. One thing as these negotiations goes forward is that the commission doesn't want to lose a Schrems 3. They want to get it right this time. It was embarrassing for them to lose Schrems 2, and they talk about the need to follow the rule of law. Their highest court has spoken. They can only reach an adequacy finding if the rule of law is being upheld. So there's active negotiations on the Privacy Shield. The commission had a team in Washington 2 weeks ago for 2 full days of detailed legal negotiations on these issues. But the negotiations will only succeed if it meets the real EU legal requirements and if it's workable for US national security, or the US won't agree to something that's going to create untold obstacles to national security. So at the Cross-Border Data Forum and the research I'm doing with others at Alston, we're trying to assist this process by providing quality research and context and try to think of solutions. And I would say that there's progress even on this difficult issue of redress, but the timeline is not clear. I think having an agreement in this calendar year would be very ambitious. Perhaps maybe such a thing is possible, but absent some big breakthrough, I think you have to think about 2022 and not 2021. Jim, I'll stop there. Thank you.
Thanks very much, Peter. So one question from the audience: is there any effort to challenge Schrems 2 before the International Trade Organization?
The US has periodically talked about a WTO suit. For people who do trade law full time, they know how screwed up the WTO dispute process has been, and there's many issues within WTO. So the US claim would be that the US is subject of unfair discrimination because we're held to a stricter standard than Europe. And the Commerce Department and Justice Department have been holding back on that while negotiations go forward. It's one of the cannons that the US can shoot off if things are starting to fall apart, but the US hasn't wanted to fire that cannon yet.
Thanks, Peter.
Yep.
So, Wim, can you remind us just briefly of what the Schrems II judgment actually said? It's up there to me in the pantheon of misunderstood and misinterpreted decisions. Certainly there's the Schrems version, and then there's what the decision actually said. So can you, that as a baseline, describe what the judgment said, and then I'm going to ask Hillary to talk about the EDPB recommendations.
Sure, Jim, and I think it's important to remember that there are really two main parts to the most recent Schrems decision. On the one hand, the Court of Justice found it necessary to invalidate the EU-US Privacy Shield as a framework for transferring personal data from the EU to the US. Remember also that the shield was based on an adequacy decision from the European Commission, and that the court found that decision was flawed because the Commission did not properly assess the limitations on data protection resulting from US law, right? So that's the first element. But on the other hand, the court also confirmed that the European Commission's standard contractual clauses are actually a valid mechanism for transferring personal data outside of the EEA. But the court also reminded everyone that personal data that's protected by the GDPR should remain protected wherever the data goes. And that transferring personal data to third countries cannot be an excuse for undermining or watering down the safeguards that are afforded in the EEA. At the same time, the court also recognized that the level of protection in third countries does not need to be identical to that guaranteed within the EEA. And there's a lot of misunderstanding around that, I think. It should be essentially equivalent. Now, according to the court, the standard contractual clauses can actually serve as a data transfer tool that ensures contractually an essentially equivalent level of protection for data that's transferred outside the EEA. So that's actually very positive. But then the court quickly added that companies relying on the clauses have to verify on a case-by-case basis that the laws in the country of destination do not undermine the level of protection provided by the clauses. Otherwise, they have no effect. And where necessary, data exporters may need to actually supplement the standard contractual clauses with additional safeguards to ensure that there's a level of protection in line with EU law. In other words, you may need to fill any gaps in the protection and bring it up to the level required by EU law. Now, the court does not specify which supplementary measures companies should implement. So they must always be considered on a case-by-case basis. And if you're a data exporter, you're not able to put in place appropriate supplementary measures, then basically you are required to either suspend or end the transfer of personal data to that third country. Or else the supervisory authorities can actually step in and order a transfer suspension or prohibit the transfer of data. So just to summarize, Jim, I think that the court really conditions the validity of the standard contractual clauses on a duty for data exporters to A, evaluate the legal landscape of the recipient jurisdiction, and B, take any supplementary measures that are necessary to ensure that the data remains protected in accordance with EU standards. And maybe a very quick word on what happened after that. I think you already alluded to that, but immediately after the decision, everybody was wondering, what are we supposed to do now? They were looking at the European Data Protection Board for guidance. And the EDPB came out with some preliminary guidance right after the decision, but it actually took them several months to prepare draft recommendations, and then another 6 months after they received several stakeholder feedback to publish their finalized recommendations last month. So, a lot of work went into the recommendations that we will be discussing today.
Thanks, Wim, very much. And I think that leads us to the supplementary measures, the additional safeguards. So one way that one might frame the Schrems 2 decision was that the commission got their adequacy judgment wrong. So here, data exporters, you conduct an adequacy determination and adopt the supplementary measures that are appropriate to meet the law as laid down in Schrems 2. Hillary, can you talk about the EDPB guidance and where it ended up? And I know you've got some very practical thoughts on where we go from here.
Yeah, thanks, Jim. And it was so great to hear Peter and Wim's perspective on this. So I am going to attempt to bring a practical lens to this, as it's very much of what my focus has been over the past couple of decades. And I think it's important to point out that it's so challenging for us in advising the business, but for business people to figure out how best to deal with this. I think, as I alluded to before, one of the benefits of framework-driven approaches to cross-border data transfers that we had with Safe Harbor up until 2015, and then we had for a few years with the Privacy Shield, and hopefully we have something going forward, is that it allows businesses to really focus in on being accountable in their data protection practices, really engaging the right people in the business and putting things in place that allow for management of privacy and data protection requirements effectively. And unfortunately, what has happened in the situation we're in now has not only moved us away, at least on a practical basis, from focusing in on what it is you can put in place to protect data and to respect individual rights, but really needing to look very transactionally at every single thing that you're doing at a level of detail that, quite frankly, is very difficult for most, because you're coupling the nuances of the law, and not just privacy and data protection law anymore, but also surveillance law and other laws in countries that oftentimes you have very different experts that work on these things, together with understanding data and understanding technology and understanding supply chains. It's incredibly hard. So I start with talking about this practically through that lens, because it's important for people to figure out how to get started. And what I have seen over the past year with trying to help people grapple with this problem is that most people are so overwhelmed with how significantly huge it is that they don't even know where to start, right?
So Hillary, just as a commentary for you and for the audience, I mean, we have what I'll call service provider or data importer clients that are beginning the process. Most of our controller data exporter clients are deers in headlights, and we're trying to get rid of the deers in headlights. Oh my goodness, I've got 400 vendors in 8 different countries. What do I do? So,
Absolutely.
Yeah.
Yeah, so I think looking at the 6 steps, and there's a lot of words in there, but focusing in on what do they really mean for businesses. And I think as lawyers, and most of us tend to think about, all right, what do I need to do with respect to updating all of my contract templates to put in the relevant SCC clauses? And we can talk a little bit more about that in a moment. But really, what we know we need to do as a result of the guidance, and truly also the expectations under clause 14 of the SCCs, is that we need to understand our data flows. We need to understand what's actually happening with the data, who it's going to, what that supply chain looks like. And that really starts, from my perspective, with step 1 in the EDPB guidance, which is a subset, if you will, in my view, of something we can talk a bit more about, which is a records of processing, but not the full records of processing. It's really the transfer. So knowing what data, for what purposes, why it's needed, who it's going to, etc., is the really important part of step 1. And I think it's hard for people to start there, but it's essential for people to start there and really trying to pin it to the work that most companies did to prepare for GDPR. What are you actually doing with the data? But focusing in specifically, what are you doing with respect to the data flow? Now, Jim, to your point around the third parties, it's really helpful, instead of looking at this as entirely separate from everything else that you did as an organization to prepare for GDPR, to really look at it as a subset. So step one, your transfer registry, if you will, is really a subset of your records of processing. Step two is really what you would have looked at more broadly in how am I going to get that data from the country of origin to the country of destination lawfully, and what mechanisms are available to me under Chapter 5 of the GDPR. However, one of the big things I'll point out, and we should talk about, is the final version of the SCCs, which were issued in June, introduce a very interesting concept that I think for most people, they didn't even realize, because they went straight to what's the language I need to put in my contracts. So way up in the beginning in the preamble, there is a paragraph 7. And in the final version of the adopted SCCs, that paragraph 7 speaks to the fact that the SCCs may not be used in the context where the data importer is directly subject to GDPR pursuant to Article 3.2 and its territorial reach. That is a critical reason why you need to understand your data flows, because if you don't understand the entities that are obligated in those data flows and whether or not, pursuant to that particular processing, they're directly subject to GDPR, you may actually implement SCCs that are invalid. So step 2 is really understanding what mechanisms are available to you and whether SCCs are even available to you for purposes of that transfer, or whether you need to be thinking more broadly about your GDPR compliance. And then step 3, and I'll pause there because I think we'll get into the supplemental safeguards and things later. Step 3 is really your impact analysis. What you and Wim and Peter were already talking about. It's the impact analysis of that transfer, the laws of the recipient country, and whether or not the tool that you've selected for that transfer can be actually implemented effectively given the laws in that recipient country or countries. So starting with your flow becomes critical to choosing your tool, step 2, to then in step 3, actually doing an appropriate impact analysis. And what we know is you can't just look at what does the law say on its face. You need to apply that law in context. You need to be able to warranty, if you're going to use SCCs pursuant to clause 14, you need to warrant that you actually have done that assessment in the appropriate way in light of the actual data that's being transferred in the applicable law and how it relates to the specific context of that transfer. So I'll pause there, but looking forward to more debate and dialogue around what this actually means for everyone.
Yeah, so let's unpack that for a little bit. Let's go back to the recital 7. I want to be sure and get Wim's comments and thoughts. We actually have a question from an audience member on recital 7 and the territorial scope of the GDPR and what impact that has on this whole process. I think in a conversation with a client a month ago, Wim called that the $64,000 question. And earlier today, he said that the price had gone up. Can you pause over that issue for a little bit, Wim?
Sure, Jim. I think it's not only referenced in the recital, but also actually in Article 1 of the Commission decision, right? Because sometimes people say, well, if it's in the recital, what's the legal value? But it's repeated actually in Article 1 of the actual decision. So it's not an oversight from the European Commission. They really intended it to limit the scope of application of those new standard contractual clauses. And actually, I don't think it's something that's weird, because if you look at other data transfer tools like the codes of conduct, on which, by the way, last week the EDPB issued new guidance, as they hope that it'll become a more popular way for transferring data outside Europe. Also, those codes of conduct can only be used if the recipient is not subject to the GDPR. That's actually mentioned in Article 40 of the GDPR. So it's not an uncommon concept, I think. And one school of thought around that, Jim, is that if you're transferring data to a recipient who's already in scope of GDPR, meaning subject to the GDPR, has to comply with all of the rules of the GDPR, then why would you need an additional data transfer tool? But I think, we're all really waiting for the EDPB to confirm their position on that. As I said, there's a lot of writing around this particular topic. Also recently, there was a report written by a professor in the UK, Douwe Korf, on behalf of the LIBE committee, where he also points out that it actually makes sense to limit the scope of the SCCs to data importers that are not subject to the GDPR. And I think you can all actually find it in the concept of restricted data transfers that are used in the UK, acknowledging the UK is no longer a member of the EU, but nonetheless, in the UK, you're supposed to implement data transfer tools if you have a restricted transfer. So again, I think there's just a lot of discussion around when do you really need to put a data transfer tool in place, Jim? And I think the only one who can bring clarity here is going to be the EDPB.
Okay. And one of the questions asked by the audience is, if that's the understanding, then should we also use safeguards for those transfers? And to me, one would think that the safeguards and the supplementary measures have to be a part of the discussion with respect to essentially every ex-EU data transfer, because there simply are no guarantees. This is a very muddled point of the analysis, if you will. And even if you hire Alston and Bird or another good law firm to conduct a transfer impact assessment, or a good law firm in China or India to tell you about the surveillance laws and practices in those countries, there simply are no guarantees. Don't the supplementary measures essentially come into play in every data transfer, Wim?
Yeah, I think that's right, Jim. I think even if you would take the position that a particular data transfer tool is not required, you still have to address the issue of, what happens in practice in the country of the data recipient, right? Is that data recipient even in a position to fully comply with the GDPR, or is that effort undermined by local laws and practices that allow the authorities to have access to data? So I think yes.
And another kind of applicability and scope question, just to be clear, all of this applies to the code of conduct and the BCRs. I mean, for years, I think the BCRs, in my estimation, have been an underutilized data transfer tool that have a lot of follow-on positive effects in the data protection practices of a company. They've not been as widely adopted as they might have been. But do we have to worry about all these supplementary measures, data transfer impact assessments with all of the transfer tools?
Yeah, absolutely, Jim. I think the EDPB's recommendations are quite clear on that. And they say that doesn't really matter which data transfer tool under Article 46 and others you actually use. You should always consider the guidance and the impact of the court's decision. Okay,
so no silver bullet. One thing that I would commend for the audience, if you haven't read Clause 14 of the standard contractual clauses, and in fact you are relying on the standard contractual clauses, whether you are a data exporter or importer, go back and read that. I think you will find it jarring, and it may, quite frankly, add to the deer in headlights view of this world, rather than working against it. One question, Hillary, for you is, how much cooperation and support, if you think about Clause 14, where there is a warranty from I'll call it the service provider, the processor, the data importer, a warranty as to their knowledge of laws and practices in the jurisdiction in which they operate. How much cooperation and support should data exporters expect from their data importers? What form does that take? Is it a template TIA? Is it a white paper? Is it an FAQ? what does that collaboration process look like, or what should it look like?
I think we still have yet to see what a best practice may be, and we'll learn a lot over the upcoming months. But what I would say to start with, it's important to take a step back to where and how organizations currently are evaluating their third parties. So typically that happens through a third party risk assessment, or some kind of third party vendor assessment, and certainly if it's a processor activity. And through that activity, one can typically ascertain, based on the responses, what controls they have in place from a security perspective, things that would actually contribute to the kinds of safeguards that if one were doing that strictly in-house, one will be looking for in terms of supplemental safeguards. One of the other critical things, just looking at this from a in-practice perspective, then we can get to the law. From an in-practice perspective, it's really critical to know from your third parties whether or not they've ever received a request, and what their general practices are with respect to government access requests. So I think a critical piece of how this all works in practice is many companies, in fact most, have a current vendor assessment process. Some have more comprehensive third-party risk assessment processes, ensuring that you have augmented those processes to ask the relevant questions of the vendor or vendors that you need to have responses to for purposes of your total transfer impact evaluation is a really important part of the process. I see it in terms of best practice as a third-party risk assessments or vendor risk assessments with augmentation around these specific issues. And then in particular, when it comes to relying on the law of the country and an evaluation of the law of the country, I think it really depends. I think it's much more likely in the context of the C2C, the controller to controller transfer, where relying on a legal analysis that may have been done by counsel for your partner becomes more relevant, whereas in the context of controller to processor, I think most controllers are more likely going to want legal analysis that they had some direct input to. So in terms of how this all plays out, I think a report, whether that report is a white paper, probably that's what a lot of companies will start to do to simplify it and streamline it when they get these requests all the time. And then the data exporters will be looking for those transfer impact requirements to be built into vendor assessments and third-party risk assessments going forward.
So a lot of our client questions at this phase are, and this is uniquely suitable to you, Hillary, sorry to keep on coming back to you, is isn't there a technology platform that can just do all of this for me? And I mean, I think you've spent the last 5 years prior to your role at D&B thinking about the capabilities and advantages afforded by those platforms and perhaps some of the limitations built into those platforms. But let's face it, the audience members today probably have significant investments in OneTrust or TrustArc or Archer or some other compliance related tool. How does that fit into this whole endeavor?
That's a fantastic question. We could have a whole webinar just on that topic. But here's what I'll say in summary. So technology, and I'm a huge fan, as I think most people who know me are aware of, technology can be absolutely fabulous for helping to simplify and structure the problems that are really complex that we're trying to solve for in this space when it relates to the data and the workflows and the things that happen within business. So for example, when it comes to maintaining a records of processing or maintaining this new transfer registry that I'm describing as kind of a subset of a records of processing that aligns with step one, technology can be really helpful there because you can automate understanding exactly what's happening with the data and keep track of things in ways that allow you to have more structured approaches to reporting on it, getting insights and trends. Having automated assessment methodology is really beneficial for purposes of staying on top of things, being able to come up with standardized controls that can be evaluated, and doing consistent risk analyses. What I would say is really, really hard to automate is the complexity of the law here. And that I just personally feel is impossible to automate for any time in the near future, if at all, ever. It's far too complicated. And so the law, and just like the space in which we are working in generally, the law and technology need to work together, and one does not replace the other, one can augment the other. But this very, very complex legal problem that we are dealing with, and it's starting with Schrems too, but for those of us who work around the world, we know that there are other countries that place restrictions on cross-border data flows. There's a lot to be considered here. And while you can build a lot of the objective things that you need to keep track of, and some of the risk analyses into technology, you cannot fully replace what lawyers need to do when it comes to the nuances of the law.
Interesting you should put it that way. I will say that I have had several conversations over the last, say, month or so where everyone just says, well, we've got a tool for that, and I'm sure it'll be addressed in that tool. But you raise an interesting question regarding third countries. So as Peter has talked about, and others have talked about, but particularly Peter, this doesn't only apply to the United States. And Wim and I were talking about one of his clients that has, more than a dozen countries to which they transfer data on daily, weekly, on a regular basis outside of the United States. Just assessing what the quote unquote surveillance law may be. Is there a problematic law in the vernacular of the EDPB guidance? Or what if there's no law on surveillance or access by public authorities? Or more important, or perhaps not more importantly, but just as importantly, what about if there is a law that reads just fine and a practice that is entirely different? I mean, there are countries around the world that have relatively straightforward and well-documented legal systems, but then they have a ruler or a party in power that does whatever the heck it is they want to do. Can you find some local counsel that synthesizes all that for you? And Wim, I would encourage you and Peter to jump in on this one. But what, companies have spent millions of dollars and person hours over the last decade in moving their back office all over the world to more effective jurisdictions from a cost perspective. Now, what do you do?
Maybe I'll just make one short point and then Wim comes in. If there's no law, it might be that it's a small island country in the Pacific Ocean, and the no law is also backed up by a no surveillance capability. So that's a situation where the risk might be quite low. On the other hand, there might be a country, China might qualify in some respects, where there's no relevant law putting limits on government access. But we know that there's a very large surveillance capability. And so China in particular is especially problematic. We did a study a couple of years ago that was published at the Future Privacy Forum documenting China's surveillance activities and its lack of legal safeguards there. And if there's one country in the world that's especially difficult to come up with a case for, I do think it's China.
And one country with, at least over the course of the last decade, a growing presence in back office processing for corporate America. But Wim, you're struggling on a daily basis with companies with these integrated supply chains, international integrated supply chains. What are your thoughts on that?
Yeah, Jim. So I think, look, the annexes to the EDPB's recommendations do include some possible sources of information. And so that's always worth checking if there's publicly available information on the relevant laws for your particular country. But But if that's not the case, then it's not really clear what you're supposed to do, and the EDPB doesn't really go into a possible plan B there, other than saying, well, maybe you need to consult with local experts, local legal experts. I think even if there's no law, right? I mean, the EDPB again does emphasize that you also need to look at practices. And there again, how do you find out what these practices are? And if you do consult local experts and they can't find any laws and can't really comment on any practices, well, maybe then you have no reason to believe that there are local laws and practices that could undermine the protection of the standard contractual clauses, for example, right? That could be one conclusion. But I think and on some of the countries that were mentioned, and China in particular, I agree with Peter. That's probably a bigger challenge compared to some other countries out there, particularly in light of the warranty in clause 14 of the standard contractual clauses, which must be based on an understanding that the laws and practices basically respect fundamental rights and also do not exceed what's necessary and proportionate in a democratic society, right? That's the standard that the EDPB as well as the European Commission are using here. And so how can you warrant this for countries that are not even democracies to start with, right? I think that's just very tricky.
Yeah, Jim, if I can jump in and offer a comment here too briefly. I think it's important to get in and understand what's happening in practice. What I still remember all the way back when I was working on getting a binding corporate rules approval, and there was very much of a focus of the regulators at that point in time on how does your company deal with government access requests, and there's the full range, right? It depends on the company that you're in, what kinds of government access requests you may receive, and that, as I think both the SCCs as well as the EDPB guidance take into consideration the fact that you need to understand the sector, and it varies sector to sector. But I think a really important part of preparation for this for organizations, while it's not called out as explicitly, is really working through as part of your evaluation around your own supplemental safeguards. What are you currently doing in terms of receiving government access requests? How would you categorize them? What is your response process? And how does that work all over the world such that you can actually look at the impact to your organization in practice? Because the fact is, if you've never received one, and you need to consult all the right people in the organization to know, but if you've never received one, then you're in a very different posture than if you're a business that actually receives various types of requests on a regular basis. So I think that we haven't called out, but I think is a subtle point made in both reference documents here for organizations to be thinking about as part of their preparation process. Jim, you may be on mute.
My deepest apologies. I'm trying to make sure my dogs don't bark in the background. Another question feeding off of all of that is, if you do this TIA and you assess the law and practices in, let's say, Vietnam or Cambodia or India or Singapore, wherever the case may be, that still doesn't provide you a get out of jail free card. There is no guarantee. If you're using the model clauses, you're still making the warranties that are set forth in clause 14 of the SCCs. How much of an enforcement risk is there? And as Peter mentioned, in fact, it was Peter's book, None of Your Business, in 1998 that made our careers collide with one another. But since the days of the data directive, I've been getting the question, well, does all this really matter to me? They're interested in the big cloud providers and I make widgets. Is a DPA really going to come after me? And Wim, I wonder, with everything that's on the DPA's plates, is there really a practical enforcement risk for corporate, what I'll refer to as corporate America?
Yeah, Jim, well, the answer may be that it might actually depend on the member state, right? Because if you look at Germany, there we know that there's currently a nationwide and coordinated investigation into companies' compliance with the Schrems decision, right? So in other words, the German supervisory authorities have put their hands together to actually enforce the decision by sending out questionnaires to specific companies in specific areas. And I think the investigation is mostly focused on third-party service providers like email services and web hosting services, but also intra-group exchange of customer and employee data, right? So they do take it serious, and they do seem to have the time to allocate to following up on how companies are dealing with the court decision and what they're putting in place there. Now, will we see the same type of action in other member states? Probably not in the same coordinated form, I would say, but at least I think it's one example of an EU member state where supervisory authorities have actually taken action.
Well, go ahead, Peter.
Just
please.
very briefly. So you might not have thought of Portugal as the cutting edge of the hardest enforcement, but a U.S. company that wasn't supplying cloud or wasn't supplying email. Cloudflare was supplying cybersecurity services, basically, and they got dinged by the Portuguese regulator and had to withdraw from a contract with the census in Portugal. So there's some surprising ways in which we've already seen enforcement, not just in the core places where you would have looked to see it.
And for me, the practical, so I have a foot on the cyber side of the fence and a foot on the pure privacy side of the fence. But where I see those things converging, and Wim and I have seen this recently from regulators, you have a data breach or a data related incident that you have to report to the regulator. It involves a service provider, and the regulator all of a sudden starts asking questions about your data transfer mechanisms. So a very realistic scenario, sort of stepping in a deep hole in high grass, if you will, is you have an incident, it involves a service provider, you have to notify with respect to that incident under the GDPR, and then all of a sudden you find yourself in an investigation. And it is not, irrespective of one's sort of American sensibilities, it is not far afield for many DPAs in Europe to take that very scenario and start asking questions about data transfer. So I think Hillary's point of this is where it all comes together. You have to start with the basics of your vendor assessment and onboarding process, your TIA, moving into a workable transfer registry. PIAs are conducted by many companies and DPIAs in many circumstances. All of that needs to provide a platform for you to respond. And again, if you haven't read clause 14 of the standard contractual clauses, which, by the way, and I wrote the date down, the deadline for moving to the new standard contractual clauses is December 27th, 2022. When GDPR came in to effect, or was coming into effect, we put a big clock on our blog. And then we moved that to be a clock on the CCPA. And now we've got the CPRA and the Virginia law and the Colorado law and the new SCCs. So no more clocks on the blog. There's just too much for everyone to do. But you do have to move everything. Your providers that were previously relying on the privacy shield now have to be moved to another data transfer mechanism until Peter and colleagues work some magic. And all of your existing standard contractual clauses essentially have to be picked up in one form and put down in another form with these transfer impact assessments and supplementary measures and assessments all across the globe between now and December 27th. I'll ask for, I want to be mindful of the clock, but 1 minute sort of summaries from Hillary, Peter, and Wim, and then we'll conclude. Hillary,
I guess
go
what I
ahead.
would say, thank you, Jim. I guess, first of all, thank you for allowing me to be part of this great discussion today. And I would really summarize by saying, although this is an extraordinary, complex time, and things that we are dealing with are challenging to navigate through, taking a structured approach, leveraging what you already have for purposes of complying with GDPR more broadly, narrowing that down to fit and work in the context of these specific obligations around transfers, and making sure above all that you are prepared to demonstrate to a regulator upon request exactly what your plan is, and to be able to speak to things that are done, and if you have to, things that are still in progress. And what we know is the reality is so many things for many will be in progress for a period of time because this is a complex space to navigate through. But being able to demonstrate your plan and having clarity around that is really key at this point in time.
Thanks. Peter, before you go, for CLE individuals, New York, Virginia, Oklahoma, et cetera, the code is AB 228976. AB 228976, and see your contact on your confirmation form to kind of activate that entire process. Peter and Wim?
Just a very short. Even if we get a new privacy shield, there will not be a new decision for the rest of the world for transfers out of Europe. And so living with a degree of legal uncertainty, a degree of not knowing how Europe will react, that's probably the new normal for quite a while to come for companies. And that's not a comfortable place. And the rest of your company isn't thrilled to hear that from you. But saying you have an answer and you've taken care of the risk is probably a stronger statement than you'll be able to make for quite some time to come.
Wim?
Yeah, Jim, I would say, look, data transfers outside of Europe have just become a little bit more complex, but it's still doable. And also remember, everybody's in the same boat.
Yeah, all very well put. Many, many heartfelt thanks to Hillary, Peter, and Wim for sharing their thoughts with us today. We will have more sessions on this and other related topics. We wanted to get this one in before the holiday season, before the vacation season in Europe and elsewhere. I think when people redo their budgets this year, they will move to a significant effort on these issues in 2022. So we look forward to speaking with you about that and answering any further questions you may have. Thanks again from Alston and Bird to our speakers, and thanks again from Alston and Bird to our audience participants. Bye-bye.